Yo, what's going on, family? How y'all doing? How y'all doing? What's going on, family? What's up with y'all? What's going on, fam? How y'all doing, family? What's going on? Yo, what's going on, family? What's up? What's up? Yo, what's up, family? We're gonna start at 1 minute and 30 seconds, fam. What's up? How y'all doing? How y'all doing? How y'all doing? How y'all doing? What's going on, fam? How y'all doing? We're gonna start in 20 seconds. 20 seconds we start. How y'all doing, fam? What's up? What's up? How y'all evening going? We start in 10 seconds. 10 seconds, fam. What's going on, family? How y'all doing? 3, 2, 1. All right, go. All right. Now look, fam. What's up? What's up? What's up? So the title of this video today gonna be about. Now this is for a lot of trolls, right? Now I made this specifically for a lot of people who argue the fact of a person being searched or their vehicle being searched after an arrest, right? So this video gonna be about, can a police officer search your vehicle after you've been arrested? Let me explain something to you. No, and I'm gonna tell you why. The Supreme Court already ruled on it. If a person is arrested, right, and they securely is being taken away from the vehicle, and there's no immediate way of that person regaining access to the car, at that particular time, a person car cannot be searched, right? Now, the only way a person car can be searched is probable cause within the vehicle, like contraband, or if you immediately threaten an officer, or if there is anything in their physical observance, like they can pretty much see it. You get what I'm saying? So that would be the only basis of the police searching the vehicle. But let's go deeper in this, right? You got a Supreme Court case that was ruled on after New York versus Belton. So in New York versus Belton, it was a man. He was arrested for something, so the police took him outside the vehicle and they searched the vehicle. Now the Supreme Court said that was justified, right? Now the Supreme Court went against the New York versus Belton, and they made a new ruling, right? So the new ruling was under Arizona versus Gant. Arizona versus Gant was a man, he was arrested for not having a driver's license. No, he had a suspended driver's license. And so since he had a suspended driver's license, the police stopped him and handcuffed him. Once they handcuffed him, they put him in the back of the patrol car, and the police decided to search him. Once they decided to search him, they ain't found no weapons or anything like that, but they proceeded to go inside his vehicle. And when they checked his jacket inside the vehicle, it contained guns and it contained drugs. So he got convicted of the crime when he went to trial. But what happened was, when he was through the process of filing an appeal, the appellate court sent it all the way up to the Supreme Court. When the Supreme Court got the case, they ruled and said the officer searched his vehicle unconstitutionally. And I'm gonna tell you why. Anytime you are arrested for driving without a license, there's no constitutional basis of a police officer searching your car. Because one of the exceptions of a police officer searching your car was to find evidence that's supporting of a crime, right? So driving without a license won't be evidence that you're searching for inside the vehicle, furtherance of that crime. Another thing, right? If there's no probable cause as far as searching the vehicle, like you wasn't immediately endangered or anything like that, the whole goal of a police searching your vehicle under New York versus Belton was for the police officer's safety. So when they search the car, right, they're supposed to check the immediate areas before they even take you out the vehicle. So once the police decide to hurry up and just take you out the vehicle and arrest you, they have now taken you out of an unsecure area, and now you went towards a security area. Once you get to the secured area, there can be no longer a proceeding of searching your vehicle. That would be unconstitutional if they decide to search it. So all evidence in the case must be suppressed. So when a lot of people ask me, hey, how did you win your bond motion? That's how I won my bond motion. And I never brought up the Arizona versus Gant because I haven't heard of the case law until I searched. Because I was wondering, I'm like, okay, so can an officer search your vehicle? Basically, in my scenario, it would drive without a license. So that meets the same case law as Arizona versus Gant. When Arizona versus Gant, he was arrested for having a suspended license. In my case, I was arrested for having no license, right? But it wasn't technically an arrest. It was pretty much a search because I wasn't even informed that I was arrested. You get what I'm saying? So during that search, there was no probable cause initially, right? So if you guys if you guys ever been found with contraband inside your vehicle because you were searched for not having a license or anything like that, all of that evidence could be suppressed depending on how you filed a motion. Now, once I get my motion granted, the first thing I am going to do, I'm going to show you guys the motion that I filed in court. Now, I know how to file a motion and write out a motion real good, but I want to show you guys how to write it out, especially for those who are going pro se. You get what I'm saying? Monroe versus Pape. I'm gonna check that out. Yep, just like that. So after they put you in handcuffs and take you to a secure location away from the vehicle and there's no probable cause inside the vehicle, they cannot further a search. That would be considered unconstitutional. You can search it up in the oral arguments, Arizona versus Gant. If anybody want to learn about that case law and what the Supreme Court ruled on, a police officer cannot search your car for not having a license or not having insurance. Most of the time when police arrest you, they usually leave your car on the side of the road and let your family pick it up, or they can take it to the, what I about to say, you know, the tow yard. Yeah, that you can suppress all evidence. It's easy to do that. A lot of people just got to learn how to actually, go about filing the correct motion. And number one, you guys got to actually represent yourself. So if you're not exercising your Ferreta rights, remember Ferreta versus California, if you're not exercising your real constitutional rights, the court not going to listen to you. And like I said, you have a constitutional right to represent yourself, or however you want to say it, represents own self or whatever you want to say, or representing oneself, or however you want to say it, you still have that constitutional right. It's in the Constitution. You have the right to represent yourself. Whatever you want to do. If you want to challenge subject matter jurisdiction, if you want to challenge the jurisdiction of the court, if you want to challenge the constitutionality of the search, if you want to challenge anything, you got that constitutional right. But you have to set up a Ferreta hearing. A Ferreta hearing does not grant the court jurisdiction as many people think, because understand this, subject matter jurisdiction cannot be waived in any form. You can actually challenge subject matter jurisdiction even on the day of trial. So if you find errors inside of your case and the judge see a logical basis of you challenging subject matter jurisdiction, you can get your case dismissed easily. Or if you decide to do a notice of removal and transfer your case over to a federal court, you can move your case over to the federal court. If the federal court see no basis of subject matter jurisdiction, the federal court can move to dismiss the case. So you can do the trick and loopholes a million ways. Because I was shocked. Once I fought my case, I was kind of shocked. I'm like, how did he just let me go? So I was wondering, I got into the books and I started learning because during the cross-examination, I had to ask the officers those questions. And the reason why I had to ask the officer those questions was because I wanted to know strictly what's the basis of the search. Because I had to ask them, did he observe any marijuana? Did he observe any smoking or anything like that? Anything, right? Or any weapons? Have you observed it? If he said no, right? He did say no. He said no to all of those things. So that leaves us at what? Arizona versus Gant. You could not search a person's vehicle after they've been handcuffed and securely taken away from the vehicle. If you search their vehicle, if you further search the vehicle and you find anything, that would be considered inadmissible, right? So the judge would be forced to suppress all evidence and squash arrest. So that would squash out the search warrant, that would squash out the original search, that will squash out the entire case. And then you take that, you go take that to the federal courts. You take that to the federal courts, and then you file a lawsuit, a federal lawsuit. Yep, you do it just like that, fam. Yep, fruit of the poisonous tree, you said it. Fruit of the poisonous tree, that's exactly what it was. So this, I wouldn't even argue a Second Amendment case. This is a Fourth Amendment case. I wouldn't even say a Second Amendment defense. I would say this is a Fourth Amendment defense. Most of the time when I deal with Second Amendment defenses, it's usually when a gun is on you. Like if you ever get caught with anything on your actual body, that's when you could challenge the constitutionality of the gun. You could challenge the constitutionality like the Second Amendment. Yeah, family. So it worked just like that. And yeah, so I want you guys to understand that you do have rights. You have constitutional rights, unalienable rights. But you just got to know how to enforce your rights. Don't go to court just talking and screaming, "Oh, judge, I'm the secure party of the trust," because you haven't even asserted your rights. That's not even asserting your rights. If you want to assert your constitutional rights, say, under California versus Ferreta, I have a constitutional rights to represent myself. And that's your rights. And so when they do a Ferreta hearing, they just ask you simple questions. Simple questions just to check your competency, to see, do you even understand a little bit about law or a little bit about your situation? And usually after 2-3 minutes, they say, okay, the court finding of that you're competent to represent yourself. And after the court seeks that you are competent to represent yourself, that's when the court will allow you to say, okay, you can represent yourself. And once you represent yourself, you're good. And that's when you can challenge anything you want, because now you have officially fired the attorney from your case. You have officially, they have officially relinquished all obligations and everything like that. And so now you can go further of any process you want to go by. So if you want to say, I'm doing a acceptance for value or anything like that, that's perfect. I'm going to tell you something, right? I know a lot of you guys seen that famous case with the Moors when they went in court and they was arguing with the judge, right? Those brothers did a fantastic job. But the problem is they missed something so small. It was a Ferreta hearing. All they had to do is tell the judge, say, I want to represent myself. I have the constitutional rights under California versus Ferreta to represent myself. And the judge would have just literally did a Ferreta hearing right then and there. You get what I'm saying? So most of the time, when you want to assert your rights and you want to represent yourself, you have to let the court know that. The judge can't be the one to initiate you represent yourself. Hey, sir, would you like to represent yourself? Because most 100% of courts only operate on presumptions. They're presuming that you need a lawyer. They are presuming this. So you cannot blame them for making a presumption of something that they do on a daily basis. They go through 1,000 cases, and out of those 1,000 people, 1,000 of them have attorneys. So you are a different situation. It's not common where a person go to court to represent themselves. You get what I'm saying? If they arrested you for a DUI, most of the time when they arrest you for a DUI and they see an open container, yes, that's when they can search the vehicle. The Supreme Court already ruled on that. So say, for instance, that would be considered contraband. So if you got the liquor opened and they search the vehicle, then yeah. But if you had a DUI and there's no open liquor in the car or whatever the case might be, that won't give them probable cause to search the vehicle. If anything, they'll tell you step out. If they don't see anything in plain sight, they're supposed to close the door and take the car to impound, or they just have someone pick it up and arrest you. You get what I'm saying? So it usually works like that. Yeah, they arrest you for a DUI, but I don't know if they'll search you. Unless you got an open liquor container. Most people do. So if you got a DUI, 9 times out of 10, most people have the liquor open. Any open liquor container bottles, automatically they're going to search it because that'd be considered as contraband. Because that'd be like you driving and you drinking. You get what I'm saying? And if you want to challenge subject matter jurisdiction, you can as well. You know, everybody's situation is different. Like me, I'm a constitutionalist, so I always dealt with the law. I never cared too much about challenging jurisdiction because I know we're gonna beat the case. But in many circumstances, everybody different. If I was in a situation where I was guilty at 100%, I would challenge jurisdiction. I would challenge the subject matter jurisdiction. I would transfer the case over to federal court. I would be doing the acceptance for value. Because now, if we had to deal with the facts, I wouldn't win if it comes to the facts. But since it comes to the facts and we have all the facts in our advantage, why wouldn't I do that? You get what I'm saying? Yeah, family. But any questions? Any questions? Peace, peace. Peace. Philly, what's up, bro? Yo, what's up, bro? Terrence, what's up, fam? But no, but you know, that's how it mainly is. So you just can't allow the police to search your vehicle. Even if they decide to, you can always suppress any evidence that's obtained and take that right to the federal court and sue. I would never sue in state court. I always sue in federal court. Yes, sir. But yeah, family, that's all I had to say. You know, I want you guys to take this information. I want you guys to learn from this information. I like to push peace, and I like to push, you know, knowledge to you guys and everything like that, so you guys can know y'all rights and everything. You know, peace and love. Oh, the case going excellent, excellent. Ain't no case. If you ask me, ain't no case. Ain't no case. All right, I'm out. Peace and love.